Hello everybody, welcome to the Hare Court webinar, which is going to be given today by Thomas Roe, Queen's Counsel, and Daniel Black of Hare Court. As before, we're going to hopefully end the session with some Q&As. If you can push those questions through the chat or Q&A buttons at the bottom of the screen, and then I will put those to Thomas and Daniel at the end of their talk. Tom Roe QC practices mainly in the fields of commercial and chancery litigation and arbitration. He's advised in many corporate and insolvency related disputes, and we will be focusing on one of his recent High Court decisions later on in the webinar. He also specialises in constitutional and public law and regularly acts for and against British and overseas governments. Our other speaker today is Daniel Black. He is a junior in Chambers specialising in insolvency. He has a wealth of experience in all levels of court and in both corporate and personal insolvency matters. I will now happily hand over to our first speaker, which is Daniel Black.
Good afternoon, everyone, and thank you for joining us today. In May of this year, the High Court gave judgment in Stubbins Marketing Ltd and Stubbins Food Partnerships Ltd. In the course of his judgment, Mr. Justice Trower considered and applied the Duomatic Principle. That is, the principle of law that where it can be shown that all shareholders who have a right to attend and vote at a general meeting of a company, and the assent to some matter, which a general meeting of the company could carry into effect, that assent is as binding as a resolution in a general meeting would be. As you have heard, Thomas is going to speak about that case, but before that I'm going to take us on a dive, as it were, into the Duomatic Principle and consider some of its areas of operation. In doing so, the aim is to set a framework for Thomas's discussion of Stubbins. So if I can step forward before tacking back a bit. Section 281 of the Companies Act 2006 provides that a resolution of the members or of a class of members of a private company must be passed as a written resolution in accordance with Chapter 2 of that Act, or at a meeting of the members to which the provisions of Chapter 3 apply. But subsection 4 continues. Nothing in this part affects any enactment or rule of law as to things done otherwise than by passing a resolution, circumstances in which a resolution is or is not treated as having been passed, or cases in which a person is precluded from alleging that a resolution has not been duly passed. The importance of that language is in inverse proportion to its mundanity. What it does is preserve the common law position that shareholders can approve certain decisions by informal consent. In other words, it preserves, though does not codify, the Duomatic Principle. If we can tack back at this stage then, the common law principle of decision-making from shareholders by way of informal unanimous consent has evolved over time. The point of departure for our purposes is in 1969 in the case of In Re Duomatic, which gives the principle its name. The context was of a company that sold washing machines. It was incorporated in 1960, but already by 1963 it was not prospering. The initial directors of the company had changed due to a quarrel between them, which occasioned one leaving. However, one of the original directors, a Mr. Elvins, remained in position by the time of the company's liquidation in 1964. He is pretty important for our purposes. The other directors at the time were Mr. East, another one of the original directors, and Mr. Wood, who was a representative of the finance company which financed the business. Mr. Elvin's role in the drama was as follows. The directors drew sums from the company from time to time as their personal needs required. And at the end of each financial year, these drawings were totaled and the totals were grossed up in order, as you would expect, to account for tax. In the year which ended the 30th of April 1963, Mr. Elvins drew around about £10,000, and this was recorded as a director's salary, along with that of the former director. These accounts were signed and approved by Mr. Elvins and by Mr. East as directors. In the following year, Mr. Elvins drew £9,000, which appeared in the draft profit and loss account, but no final accounts were ever prepared or approved. When Mr. Wood joined the board in April 1964, Mr. Elvins agreed, in reflection of the unhappy financial position of the company, to accept a lower remuneration. However, when the company entered voluntary liquidation in May of that year, Mr. Elvins drew a sum in excess of that agreement. No managing director had ever been appointed, and none of the directors had any contract of service. As such, the situation was that payments were made by the company by way of payment to directors without complying with the company's Articles of Association. The reason was that no resolution authorising the directors to receive remuneration had ever been passed in a general meeting of the company, as was required. So it was on this basis then that the liquidators sought repayment of the sums that had been made to Mr. Elvins and the former director respectively, on the ground that such sums had never been voted for in a general meeting. Mr. Justice Buckley, however, held as follows: where it can be shown that all shareholders who have a right to attend and vote at a general meeting of the company assent to some matter which a general meeting of the company could carry into effect, that assent is as binding as a resolution in general meeting would be. To unpack the principle further, it's formed of two distinct parts. So the consent of the shareholders to the relevant matter needs to be unanimous. And that consent must be given by the shareholders in full knowledge of the relevant matter. And to that knowledge requirement, we must return later. However, while the principle has been invoked successfully in a wide range of circumstances, its application is not universal. It has limits, and its scope has been considered by the courts on a number of occasions. The first potential limitation, what we might call the legality limitation, works in the following way: to the extent that a formal member's resolution would not have been valid, for example, if it amounted to fraud, then any related purported duomatic assent will likewise be invalid. So, for example, the Duomatic Principle cannot be applied to approve or ratify a transaction amounting to an unlawful return of capital. There are also potential limitations based upon a company's financial position. A company's financial circumstances may preclude the application of the Duomatic Principle. If a company is facing financial difficulties, such that at common law, the requirement to consider the interests of its creditors arises, then it may not be possible to apply the Duomatic Principle to ratify breaches of duty or non-compliance with the Companies Act on behalf of the directors. Now, this was articulated by Mr. Justice Newey in a case called Stakefield Midlands and others, and Dorfman and another, where Mr. Justice Newey referred rather to the fact that the interests of creditors can intrude, intrude was the term used, and that the application of Duomatic may be barred even where a company may not be technically insolvent, but is in financial difficulties. Another limitation on the applicability of the principle is what we might refer to as capability to vote. So it appears that if a company has on its register of members a registered holder of voting shares, which is incapable of voting for any reason, for example, because it's a deceased member or a dissolved corporate entity, then this will serve as a bar to the company being able to avail itself of the Duomatic Principle in relation to shareholder decisions. The case which articulates that is Randhawa and Turpin, and that was from the Court of Appeal in 2017. What is clear and critical is the idea of consent. And it is clear that the application of the Duomatic Principle is dependent upon the consent of all the shareholders with a right to vote, and it is clear that a majority will simply be insufficient to invoke the principle. This raises issues both with respect to the form of consent and as well as with respect to the knowledge base of the would-be consenters. An agreement to amend the constitution of a company can be inferred by conduct, and this may include acquiescence in circumstances where members knew that their assent was being sought. However, when relying on conduct in support of an informal amendment of a company's articles, the conduct must be such that on the balance of probabilities, the members intended to amend the articles in the particular way contended for. That's a principle drawn from the case of Sharma and Sharma in the Court of Appeal in 2013. But consent is also about information and about the level of information which those would-be consenters have. Where the shareholders have assented to a matter without being fully aware of its extent or implications, then it may be that the Duomatic Principle is not available to save the transaction. So, for example, in the case of EIC Services Limited and PIPS in 2003, one issue was whether the issue and allotment of bonus shares had been effectively authorised by the members, as was required by the company's articles. Now, the members had been told about the proposed issue, but there was no question of their consent having been sought, nor of it having been given. Mr. Justice Neuberger, as he then was, held this was not sufficient to authorise the bonus issue. Now, that case did go to the Court of Appeal, but it was not overturned on the authorisation issue. The shareholders therefore must ratify or mandate the act in question, whether formally or informally, in the knowledge that their consent is necessary. In the rather fabulously named case Re de Jan of London in 1993, Lord Justice Hoffman held that the fact that consent would have been forthcoming if it had been sought is not enough. Another commonly trailed issue in this area is whether acquiescence can mean consent. And so long as it is made with the full knowledge of the relevant matters, then acquiescence can amount to consent. But there are limits to this principle. And there is the case of Schofield and Schofield in 2011 in the Court of Appeal considers this. There, the court was required to consider whether a purported general meeting was valid and effective under the Duomatic Principle, despite being called without the proper period of notice required under the Companies Act of 2006. Now, what had happened there was an aggrieved minority shareholder had been removed as sole director. Now, it was alleged that by virtue of attending the meeting, the minority shareholder had treated the meeting as valid and effective despite the lack of proper notice, and that by attending and voting, the shareholder had in fact actively agreed to the validity of the meeting and the business transacted there. This argument was rejected, and the Court of Appeal held that nothing short of unqualified agreement, objectively established, would suffice, and that on the facts there was no such agreement by the minority shareholder to the meeting's validity, nor to the business transacted at it. Now, we have at this stage looked at a relatively high level of principle as to how the Duomatic Principle operates. But now a more context-specific question arises. Can the Duomatic Principle be applied in relation to the requirement for shareholder approval of substantial property transactions? The courts have said yes before. They said yes in re Torvale Group, and they said yes in re Conograde. And they have very recently said yes still once more. And in fact, they did so in Stubbins Marketing Ltd and Stubbins Food Partnerships Ltd, at which point I think I should pass over to Thomas.
Well, thank you very much, Daniel, for that overview of the Duomatic Principle. The first thing I need to do is to check that I'm not muted, which is my usual mistake when doing Zoom calls. I think by the time the pandemic is finally over, I will work it out and do it every time, but I think I'm okay. I'm going to turn now to look at the Stubbins case in a little bit of detail and what we can learn from it about how the Duomatic Principle that Daniel has just reminded us about can be applied and sometimes can't be applied to validate decisions that ought to have been the subject of company resolutions, but in practice weren't. I should say at once that I will not be claiming that the case makes some radical change in the law, but what it does do, I think, which is useful, I think, to anybody whose work requires them to be aware of the Duomatic Principle, is that it provides a vivid example of how the principle works in practice. It also touches on how the principle works in situations that are perhaps more complicated than the paradigm case of the company with several equal shareholders. And I think also in one respect, it's quite an important corrective to one aspect of the current case law. And I'll come back in a bit to explain what I mean by that. But I should start by saying something about the facts of the case. And I say I'm going to start by saying something about the facts of the case because there simply isn't time to give you a complete account of the facts, in respect of which poor Mr. Justice Trower, who was the trial judge, was in fact, I think, trying his first big case as a High Court judge, had to spend several weeks listening to evidence and poring over documents and indeed listening patiently to counsel's arguments. He, of course, had to listen to us because that's his job. You've got a choice in the matter, but I don't think I would have any audience left by the end of it if I gave you the full story in all its detail. So I'm going to paint a somewhat simplified picture, perhaps with rather broad brush strokes, but filling in the gaps in a bit more detail from time to time where I need to in order to make some sense of what I shall have to say. So to the story of the case. The story starts, perhaps like many tales of corporate success that lead eventually to feuding and litigation, the sort of thing that warms every litigation lawyer's heart. It starts with one generation of a family setting up a business and doing, in fact, very well. In this case, it was two brothers and a sister who came to this country from Sicily in Italy in the 1950s. They leased a little bit of land and they began growing fruit and vegetables. And all three of them played a significant role in the running of the business, which they effectively owned between the three of them. Their business grew and grew in both senses of the word, I suppose. And by the beginning of this century, by 2000 or thereabouts, they owned multiple nurseries. They had their own in-house logistics business. They ran a successful import business as well to cover for that part of the year when the British weather wasn't up to producing salad, produce and vegetables and so on that the supermarkets would want. But overall, as a result of all of that, they were one of the major suppliers to the UK supermarkets with several hundred staff and tens of millions in turnover. And it was a very successful business. Then came what, with hindsight, I suppose you might call, if this were a Greek tragedy, the peripeteia, the thing that turns out to be the turning point in everyone's fortunes. And that's this: it was time for the younger generation to get involved. And it's an old story, I expect, to many of us who have seen over the years how corporate disputes, particularly in successful private companies, get going. Each of the three founders had children and they wanted to start the process of passing the business on to them. And I expect they wanted to do it at least 7 years before they passed away for obvious reasons. Well, up to this point, the company, which for reasons I confess I've forgotten was called Stubbins Marketing Ltd, the company had been organized very simply. There were 300 shares and the three founders had 100 shares each. And that was that. And as I said, they were all playing an active part in the business, and consistently with that, they were all directors of the company. Well, in order to make it possible for the younger generation to get involved in a sensible way, what they did was to increase the share capital to £300,000 and to divide it into 3 lots of 100 shares, the A ordinary shares, the B ordinary shares, and the C ordinary shares. So 100,000 each of those 3 sorts of shares. They were equal shares in terms of ranking with each other, but the idea was that each of the founders would, to start with, hold all of the relevant group of shares, but will be able to pass some or all of those shares over time onto their children as they wanted to do so. And new articles were set up or were adopted to reflect this reorganization. The members of the company were divided into Group A, Group B, and Group C, depending on what sort of shares they owned. And the articles provided for each group to hold group class meetings at which a group class representative could then be appointed. And they contemplated that an annual general meeting of the company would actually consist of a meeting not of all of the shareholders, but of all of the group class representatives. They would be the only ones who would have a vote, and indeed the articles said that the meeting wouldn't be quorate unless each of the 3 group class representatives was present. Well, the founders duly began giving away large parts of their shareholdings, though not all of them, to their children, and so that in the end there were 12 shareholders in the company. They also, the founders that is, they began withdrawing from the day-to-day business of running the company, although it was a dispute at the trial as to exactly to what extent they had and had not withdrawn. But at any rate, it was certainly time for the next generation to start taking over not just the ownership of the business, but also its running. And there we hit the next problem, because human nature being what it is, only some of the children had any interest in running this fruit and vegetable business, successful though it was. Some were quite keen on doing it, others preferred to make their own lives doing something different. So it ended up in practice that the business was mainly run by 2 directors who both happened to be sons of the Class A shareholder. And their names were Pietro, who was known as Peter, and Salvatore, who was known as Sammy. And later on, they were joined by an external director who was a friend of theirs, who was very much on the same wavelength as them. He wasn't Italian, he was called Wayne. So Peter, Sammy, and Wayne were a close-knit team. Not long after these changes, the other thing that started to change was the overall business climate. The big supermarket chains cottoned on to the fact that they didn't need to pay the company to be a middleman between foreign companies selling produce, and then they could go straight to the foreign companies. They began to drive down the price they were paying for the domestic produce as well. And all of that put pressure on Stubbins' bank account with Barclays, and it put the company not into necessarily fatal difficulty, but certainly under some pressure. And it certainly wasn't to say that all was lost for the company. There were savings to be made to lower the prices that could be charged, so as to keep profitability at a sensible level. And importantly, they decided to copy the supermarkets in a way and cut out a different middleman, cut the supermarkets out as the middleman between the producer and the customer, thanks to the internet and modern companies like HelloFresh, which sell directly to consumers. It was possible to get into that market. So there was quite a lot still going on. And although Barclays weren't exactly thrilled at the size of the overdraft, they were still willing to finance the business. Now, we're talking about Stubbins in the context of Duomatic. In fact, lots of other things were going on with the company which had to be dealt with at the trial. Some of them very dubious indeed, others at least arguably dubious, and many of them giving rise to questions that Mr. Justice Trower had to decide. And for that reason, his judgment is a fairly rich source of material about all sorts of other corporate and insolvency related issues, like directors' duties and rescission of a debenture that was granted to one of the directors, and various other things. But let's focus for present purposes on Duomatic and how the principle came to be applied in this case. Because in short, what was decided was that there should be a transaction which the 3 directors I've talked about, together with the support of the Class A founder shareholder, decided should take place. They called it either a buyout or a restructuring. And the gist was this: they incorporated 2 new companies to take over the Stubbins business. They were companies owned by them personally, not by all of the A, B, and C shareholders of the Stubbins business. And they secured an offer of bank finance for those new companies that was enough to pay off the money that was owed by Stubbins to Barclays, but only just. And what they proposed was essentially that Stubbins should sell its entire business and one of its major sites to these new companies, basically for a price high enough to enable Stubbins to pay off the bank, not much more. And Stubbins would retain its principal nursery premises, but then immediately lease those premises back to the new companies. In this way, Stubbins would cease to be a trading company with uncertain prospects and a large bank debt, and become essentially a landlord with no debt and premises which were leased out. Well, my clients in the case took the view, and I expect they still take the view, that this whole transaction was basically motivated by greed on the part of the three directors. It would hardly be the first time that that sort of thing had happened in cases that we all come across. Mr. Justice Trower was a bit more forgiving about the directors' motivations. He decided that they had genuinely persuaded themselves that what they were doing was in everybody's interests and not just their own. For my part, I think, reading between the lines, part of it is a reflection on the part of the directors who were doing the work, that they were carrying along with them, effectively their cousins who were effectively sleeping partners. But at all events, the way in which the directors set about this transaction and putting it into effect is certainly a cautionary tale for anybody who's instructed in connection with any transaction. And while I know this is probably a gathering mostly of litigators, those of you who will have transactional work to do from time to time will no doubt have the point in mind. It ought to have been obvious from the start that the directors had a different interest in this matter from the company. The company's best interest would be served by getting the best price possible for its business and its property. The directors' best interests were, of course, exactly the opposite, getting hold of the company and the property for their new companies for the lowest possible price. So the obvious first step would have been to appoint a solicitor to advise the company. In other words, in practice, to advise all the shareholders who were not taking part in the transaction, but who were just shareholders in the company that was parting with its business and its property. And indeed, Mr. Justice Trower, in his judgment, said that that was absolutely elementary in a transaction of this type and size. Directors of the company would come under a duty to ensure that the company had separate legal advice from the advice being given to them in their capacity as purchasers. That didn't happen, except to a very limited extent, in the sense that some of the shareholders did receive some legal advice. Well, in due course, the transaction went ahead. It's fair to say, for reasons that I will touch on in a moment, that the transaction did have the broad support of the shareholders of the company, indeed all of the shareholders of the company, albeit very reluctantly, including the three founders, the original Class A, Class B, and Class C shareholders, who were still shareholders of the company, albeit, as I say, very reluctantly in the case of some of them, and consent to it, agreement to it was given, not only reluctantly, but in the light of a rather bleak presentation of the outlook for the company if it didn't go ahead by the directors. But not long afterwards, the B and C shareholders woke up to what had happened. They were particularly concerned to discover that the price at which the company had sold the main property asset was below market value, and indeed, as it turned out, below a valuation which the directors, the naughty directors, as it were, had seen, and the rent that the company had agreed to accept for the premises from the new companies was also below market rate. So they called a meeting, they removed the directors from office, they put new directors in place who caused the company to instruct solicitors who began a claim against the directors personally, and among other decisions, rightly or wrongly, very kindly instructed me to present it. Now, in that respect, the Stubbins case is very like one in which the management of a company is taken over not by new directors appointed by the majority, but by a liquidator. I should make it clear that it was not suggested in our case that the company was actually insolvent. And that's important because, as Daniel has mentioned, the Duomatic Principle is really concerned with situations where what matters is what the shareholders' interests require, and particularly, specifically, whether the shareholders have consented to something being done. It's much harder to see its relevance where the state of the company's finances is such that the interests of creditors, as the cases say, intrude into the equation, so that it's not necessarily enough to say, well, the shareholders agreed to this, so that's that. It's not enough, for example, to say that in answer to a claim that there's been a breach of one of the statutory fiduciary duties by the directors. But to revert to our case, where that's not the case, the position is really this: there's no hard and fast rule that company directors can't cause their company to deal with companies in which they themselves are personally interested. But as Daniel has mentioned, Section 190 of the Companies Act comes into play. That does lay down a hard and fast rule. A company may not enter into an arrangement under which a director or a person connected with the director acquires, whether directly or indirectly, what's described as a substantial non-cash asset of the companies, unless, this is the important qualification, unless the arrangement has been approved by a resolution of the members of the company. Well, the transaction in this case was clearly caught by section 190. We didn't spend time on the definition of a substantial non-cash asset, but on any view, this was certainly just that. But there was no resolution of the company approving the transaction. So on the face of it, the transaction was caught by section 190, which hadn't been complied with. And therefore, on the face of it, the directors were stuck with section 195, which says that any director who enters into such an arrangement, directly or indirectly, is personally liable to indemnify the company for any loss resulting from the transaction. And of course, it was the company's case that loss had resulted because the price that had been paid under this transaction was not a proper price. This, however, is of course where the Duomatic Principle potentially comes into play. And as we've been reminded by Daniel, the principle applies where the law requires there to be a resolution, and it applies in such a way that the court will sometimes proceed as if there had been a resolution approving something, even if there hasn't, provided that the thing that needed a resolution, the thing that could have been authorized by a resolution, has in practice been the subject of unanimous, fully informed consent by all of the people who would have been entitled to vote if a resolution had been proposed. Now, there was some basis in the Stubbins case for arguing that such consent had indeed been forthcoming. And we conceded, as a matter of principle, inevitably, I think, that the requirement under section 190 for the existence of a resolution, if you were to get a transaction through, as it were, under section 190, could be met in principle by consent under the Duomatic Principle. But there were three arguments, really, that the judge had to deal with as to whether it could, in fact, be demonstrated, whether such consent could be demonstrated on the facts. The first related to the fact that under the constitution of this company, as I mentioned, things weren't as straightforward as they're just being shareholders who had to vote at an annual general meeting, or an extraordinary general meeting for that matter. Under the constitution of this company, a company resolution would not have required every single shareholder to be given the chance to vote. As I mentioned earlier, on the contrary, the way it was set up to work was that a general meeting would be a meeting of the three group class representatives, each of whom would in turn have been appointed by the members of the respective group. So would it be enough to show that the transaction had been assented to just by each of the three group class representatives? That was relevant because the three group class representatives, it was said, were the three original shareholders, and they, in particular, one could see, had in the end consented to the transaction. Well, as you recall, the Duomatic Principle requires the informal but fully informed consent of those persons who could have attended and voted at a company meeting, which is not necessarily the same thing as the shareholders. So was it enough that just the group class representatives approved this? Well, in an earlier case called Blindley Heath Investments Ltd, the Court of Appeal had said actually that it was doubtful whether the Duomatic Principle could apply to representative assents, though in the end, on the facts of that case, it didn't need to decide the point. Mr. Justice Trower, in our case, disagreed with those doubts. In his view, the matter was pretty straightforward. He said, essentially, if all apparent group class representatives agree to a course of action being taken by the company, then the only issue, assuming their consent is fully informed, which we'll come back to, then the only issue is whether all the persons who are claiming to be group class representatives really are group class representatives. Have they been properly given authority? Do they retain authority as such to exercise their rights as group class representatives? And it seems to me that the judge, with respect, was quite right about that, and that the Court of Appeal's doubts in the earlier case of Blindley Heath Investments were probably wrong. If shareholders have chosen to set up a company in such a way that class representatives exercise all of the voting power at meetings, then they have to take the consequences of that. And if those class representatives, at a time when they are still endowed with the capacity to do that, they haven't had it taken away from them, consent to something under the Duomatic Principle, then their consent is as valid as their votes would have been had there been a formal vote. Happily for my clients in the case, that conclusion on the law didn't affect the outcome of the case, because the defaulting directors were in the end unable to show that anybody really had been validly appointed as a group class representative. This turned out to be one of those cases where the company had a very well worked out and elaborate set of articles of association, but in practice it didn't tend to get followed very closely, and nobody had actually thought to appoint anybody as a group class representative. So it was back to the question of the consent of all of the shareholders. Subject, however, to this second argument. I said there were three arguments, and this is the second one. It's quite closely related to the argument about group class representatives. What was argued was this: quite apart from whatever the articles had said, the founder shareholders were in practice the representatives of their respective groups of shareholders. They were described as the de facto or the proxy representatives in the argument. And there was perhaps some factual material in the evidence to support this argument, although the founder shareholders had to a large extent withdrawn from the day-to-day running of the company. It did seem to be the case, as perhaps you might expect in a company like this, where the founders had been the ones who set the thing up and ran it for so many years and had all the expertise, and people deferred to them because they were the ones who, after all, had brought about this marvelous, valuable company. People in practice, the younger generation in practice, deferred to them very often when it came to major decisions. So perhaps there was a consensus among the shareholders that whatever the founders thought was right for the company really was right for the company, and that's what mattered. Well, we submitted that wasn't good enough. We accepted, by reference to an earlier case called Sherlock Holmes, which I think Daniel might have mentioned in passing, that it's possible for shareholders to reach an agreement by conduct under which the articles of association are to be varied. Sherlock Holmes was a case in which there was a provision in the articles that said that you had to be a member of the company to be appointed a director. But for several years, the members of the company had appointed somebody who wasn't a director of the company to be a member of the company, rather, to be director. And the court was prepared to say in those circumstances there was, by conduct, an informal decision by the members of the company unanimously to change the terms of the articles of association, and therefore it followed that when somebody else came along who was not a member of the company, that didn't matter, because by then the articles had been informally altered. And it reflects the principle that the articles of association, the constitution of a company, is a contract between the members, and like any contract, you can agree something with your corresponding contract party as to what each of you will do. But if you get together and say, look, whatever the agreement says, let's change it, then generally speaking, you can do that, and that affects a change in the contract. So that was the argument there. But we submitted in our case that nothing short of an actual change in the legal terms on which the parties had agreed to work in terms of the articles of association would do. A mere practice over the years of deferring to people wasn't good enough. We said the Duomatic Principle requires the informed consent of every shareholder with a right to vote. And we succeeded in that respect. In Mr. Justice Trower's view, that meant a legal right, enforceable as such in accordance with the terms of the statutory contract, i.e. the articles. And again, happily for us, that argument succeeded, and the standard was not met on the facts of the case. But again, it seems to me that Mr. Justice Trower was surely right about the law there. So the case perhaps helps with some of the boundaries of the Duomatic Principle when one is talking about cases in which it's not as straightforward as simply a bunch of shareholders and have they or have they not all agreed. That left the third argument. As I've said, the shareholders of the company weren't very enthusiastic about the idea of the company selling its business and most of its assets to the new companies, which of course were owned by some only of the directors. But in the end, they did indicate their consent to it one way or another. And in particular, for reasons I won't go into now, the transaction did in practice require that all of the shareholders had to sign various documents in order to give effect to it. Their signatures to these documents were procured at a meeting of all of the shareholders. Well, we argued this wasn't enough because not all of the transaction documents had required the shareholders' signatures. For example, the sale of the business was a matter that could be dealt with by the directors. So the directors signed the contract there on behalf of the company. It was only because some property was involved in which there happened to be some personal interests of various members of the company that, as it turned out, the signatures of the shareholders were all required as well. Well, the judge didn't accept that slightly formalistic argument. He said, if there had otherwise been a full and frank description of the transaction and its surrounding context, then it might have been possible to infer assent from the fact that the documentation that wasn't signed, but that didn't need to be signed, was available for inspection by the shareholders had they chosen to take advantage of that opportunity. But the real question in the judge's view, and I think I in truth agree with him that this is the real question, was whether at the meeting and in various other conversations that there had been, the shareholders had actually been given enough accurate information in the right way to enable them to give what the court could regard as properly, fully informed consent. And that's the other aspect of this case, which I think is quite helpfully illustrative of what you need to show to make Duomatic work as an argument. Well, the judge went back to earlier cases about what fully informed consent means in the context of a transaction which is sought to be validated under the Duomatic principle. He mentioned two cases that Daniel's touched on, EIC Services and Sharma. EIC makes the point that the Duomatic principle doesn't require that every single detail of what's proposed has to be run past all the shareholders and agreed to. It wouldn't operate if that was the case in hardly any case. In EIC, the court talked instead about the importance of at least the central aspects of the transaction being made clear to all the shareholders whose consent is required if the principle is to work. In the Sharma case, the Court of Appeal had emphasized that, as Lord Justice Jackson put it in that case, the court is scrupulous to ensure that the director has made full disclosure of all relevant facts to the shareholders. And Mr. Justice Trower added an important gloss to that observation. He said the focus is on whether the facts are relevant to the decision which has to be made. In this context, he said, the court should also be scrupulous to ensure that shareholders have an adequate opportunity to absorb and understand not just what those facts might be, but also how they might be relevant to the decision which they're being asked to make. And he also said this: full knowledge means knowledge of all the facts which are material to the decision-making process required. And, he went on, in assessing materiality, the way in which those facts are presented to the shareholders may be as important as the bare description of the fact itself. And those, it seems to me, are quite useful dicta to take into any context, actually, in which one is arguing about whether somebody has or has not received full and informed consent to a transaction, not only Duomatic, but other aspects of the law, where sometimes that which is objectionable can be made unobjectionable, provided it's done with fully informed consent. They're also important, I think, these glosses on the Sharma case, because Sharma is in other respects a case that makes it rather easy, you might think, for parties to agree, or to argue rather, that the Duomatic principle has been satisfied. Sharma was a case in which the director had decided to take for herself a number of corporate opportunities to which the company, on ordinary principles, was entitled to have first refusal, as it were. There was a breach of duty, in other words, unless what she did had been approved of by the company. There was no resolution in that case of the company approving the director taking these opportunities for herself, nor even was there any positive indication by the shareholders that they were content for her to do it. All that had happened was that she had told the directors at various rather informal occasions what it was that she was planning to do, and they hadn't really said anything or tried to stop her. And the Court of Appeal said in that case, well, it was enough that the shareholders had acquiesced in what the director did in circumstances where you might have expected the shareholders, if they objected, to speak up. That strikes me, for what it's worth, as being at best at the outer extremity of what the Duomatic principle ought to permit directors to get away with. The point in that case was sought to be taken further by an appeal to the Supreme Court, but the Supreme Court said no. So that's the way the law is as far as Sharma is concerned. But it's useful, I think, to be reminded in the present case, going back to Stubbins by Mr. Justice Trower, that Duomatic does not get going at all in the first place unless there is fully informed consent, which means, as I've said, a proper opportunity to absorb both the facts themselves and the way in which those facts might be relevant to the decision that the shareholders have to take about whether to consent or not to consent to what is proposed. Well, in the result, as far as the Stubbins case is concerned, the defendants fell at that hurdle as well. In several respects, the transaction had not been properly and fully explained to the shareholders. Indeed, in some respects, the directors had positively misled the shareholders. They had, for example, painted far too bleak a picture of the attitude of the bank towards the business. They'd essentially given the impression that the bank was about to pull the plug, when, although the bank was not terribly happy with the company, it hadn't quite got to that point. And they hadn't revealed that the price for the property that they were causing the company to sell to their own related companies, to their own companies they owned, was below a valuation that they themselves had seen. As the judge put it, the defendants arrogated to themselves the responsibility for taking the ultimate decision by driving the proposal forward in such a way that they remove the effective decision-making power from the shareholders. And that picks up another factual aspect of the case, which is that the shareholders were put under some considerable time pressure to agree to this transaction, it being said that if they didn't do it, then the transaction might fall through and things might turn out terribly for the company and therefore for them. So in the end, the defendants lost and they were ordered to pay damages, essentially reflecting the difference between the true value of everything that the company had sold under the transaction and the consideration that had in fact been paid. As I said at the beginning, Stubbins doesn't represent a change in the law, but it does, I think, and as I've said, hold some lessons for anyone who is called upon from time to time to think about whether directors' conduct can be justified on the basis that it was done with the consent of the shareholders, albeit given informally. And I will finish simply by re-emphasizing two of the most important, in my view. First of all, as I've already indicated, it's vital to look, I think, closely at the constitution of the company. To use Mr. Justice Trower's language, we're concerned with the effective decision-making power of the shareholders. Has that power been exercised in favor of the transaction that is being complained about, even if informally? So the question is how, under the Articles of Association, the shareholders' consent to a course of action could have been formally secured. Who are the persons who, if the matter had been put to a meeting, would have been entitled to attend and vote? Bearing in mind that the answer to that question may be more complicated than simply all of the shareholders. If it is the consent of those people that we're interested in, and if those people had attended a meeting and had voted in favor of the proposed course of action by the directors, would that have been sufficient under the articles to bind the company? Well, if so, and if they did give consent informally, then a duomatic argument at least gets out of the starting blocks. Though, of course, you will want to check closely how the articles work and whether there are some other factors which may mean that even if perhaps people had at one stage been appointed as group class representatives, for example, perhaps their authority did not extend to the matter in question. That all needs to be looked at. And the second point I wanted to finish by emphasizing is that the case of Stubbins is a strong warning, I think, to courts to scrutinize very carefully the suggestion that shareholders' informal consent to a course of action was, as the doctrine requires, fully informed. That requires, to use the language that Mr. Justice Trower uses several times in the judgment, a full and frank account of the relevant facts to have been given to the shareholders in circumstances that are such that they have a reasonable opportunity to take an informed decision, by which I mean a decision not just about the ultimate question, shall I consent to this, whatever it is that's being proposed or that's happening, that later on it might be said, I should have realized was happening, but also as to the prior question, what else do I need to know before I make up my mind? So I think if you are involved in a case where the duomatic type of argument crops up, this is a useful case to mine for dicta about what needs to be shown. And especially if you are trying to say, as we were, that the consent that is alleged is not good enough because it wasn't sufficiently fully informed, then this is a useful place to start. And with that, I'm going to finish, but I think, Helen, we're going to turn over to some questions.
Thank you, Daniel. Thank you, Thomas. Yes, if anybody wants to send through more questions, please do send them to the Q&A. We've had a question through, is it possible for the company constitution to exclude the operation of the Duomatic Principle?
Shall I have a go at that one?
Yes, why not?
That's a very interesting question. I mean, I think I'm not aware of a case where that's been decided, and I suppose you might or might not want to do it if you were drawing up a company's constitution from scratch. I can see why you might want to do it, I suppose, because it might make things very clear cut. But in principle, I don't see why not. Actually, I mean the underlying idea behind Duomatic, as we've been saying, is that the constitution of a company is the contract between all of its members, So the Constitution says that if you want to get a resolution passed, these are the things you have to do. You have to have a meeting. Some of the rules, of course, are supplied by statute. Some of the rules are there in the Constitution itself. You have to have a meeting. It has to be so many days' notice. The business of the meeting has to be stated in advance, and so on and so forth. And so those are all things that are required in order to get a resolution through. And the way that Duomatic works is to say, well, that's all very well, but if everybody who could have voted at the meeting agrees to it happening, then it's as if they did. And I think probably the underlying rationale is it's rather like a contract where you and I can agree numerous different things in the contract, but if we then meet up a week later or even a year or 10 years later and say, look, I know we're obliged under the contract to each other to run it this way, but let's do something different, and we agree to that, then in a sense we can informally vary the contract. There was, I suppose in this context, it occurs to me there quite recently there was a case, wasn't there, in the Supreme Court, I think called Rock Advertising, from memory. I'm not very good on case names, so I might be wrong about that. Which looked at the question of whether you could, not just in company law, but generally, whether you could have a variation of one of those contracts which says that any variation of this contract must be made in writing, where the variation was made orally. And there's a tension in that case between two different arguments. One was, well, if contracting parties want to say this agreement can only be varied in writing, then they should be held to that. And even if both of them agree later on to vary the contract orally, that's not effective. That's the one argument. The other argument is, well, that doesn't make sense because by definition, a contract is the result of two people's agreement. And if they both do agree to do something, then that they should be entitled to do it, even if what they agree to do is to change the terms of an earlier contract that said that it could only be changed in writing. Anyway, the Supreme Court came down in favor of the first view, I think, and said, no, if it's a contract that says it can only be changed in writing, then it really only can be changed in writing, even if both parties later on agree orally to change it. So that rather leads me to think that in the answer, to go back to the answer to your question, probably if one had a constitution of a company that said, for the avoidance of doubt, any consent that is by law required to be given by resolution of the company may only be given by resolution of the company and may not be given informally, that would probably be effective to exclude the principle. But we'll have to wait and see whether someone litigates that to find out definitively.
Thank you, Tom. Another question with a more insolvency tinge. I think a lot of us often come across SME companies that are typical family companies, husband and wife companies. Now, obviously, a lot of our cases will be cases where the Duomatic Principle can't apply because there's no question that the company was insolvent. But there are other cases where there's a dispute about solvency, and let's do the stereotypical wife is a director, husband and wife are shareholders. What will informed consent look like in a typical husband and wife shareholder position where only one of them is a director?
Well, it's always difficult to generalize about cases because I suppose in a way the underlying premise of your question is that every husband and wife case has a sort of similar relationship between husband and wife, and of course it may not be so. But I think that the answer is probably that the even in that rather informal context, the court will be quite concerned to ensure that the consent is true consent. I mean, I think I suppose the honest answer, I guess, to a certain extent, is as we all know, when we deal with cases on the facts, very often the overall merits of the case sort of play quite an important role, and you can use elements of the case law in reality in either direction. I mean, if you're trying to argue, or indeed I suspect if you're a judge trying to find that there wasn't sufficient consent, you can emphasize the sort of things that Mr. Justice Trower emphasized in the Stubbins case. You can emphasize the need for the consent to be not just, yeah, okay, I consent, but to be fully informed in the sense that the person who gave the consent really knew what it was that was going on, or at least knew about enough of what was going on to take an informed decision not to look any further. Very often, of course, the idea is that the person whose consent you're talking about didn't actually go through the entire transaction line by line and say, yeah, that bit looks okay, that bit looks okay, yeah, I'm happy with it. The person whose consent you're relying on say, well, I'm happy to leave it to you. But the extent to which it might be real consent to say, I'm happy to leave it to you, depends in turn upon the context and what the other questions are that a person who is interested in exercising their rights as shareholders properly would actually want to ask. So on the one hand, you can rely on all those aspects of the case law. On the other hand, if you're trying to uphold a transaction as an advocate, or if you're a judge who's leaning that way and saying, yes, there was consent to this, you can mine cases like Sharma, which talk about even acquiescence being enough, even simply saying nothing in circumstances where you might be expected to object. Though, as I said, I think I might have said in my talk, I would query slightly whether that's really right. It seems to me that's at the outer end of the spectrum, but in terms of what's permitted. But we shall have to wait and see. So I think that I'm afraid that the shorter and slightly evasive answer to your question is it depends on all the circumstances. But there's a wealth of material to mine depending on which side of the argument you find yourself on.
Well, I've got a follow-up related question where I'm happy to be given both sides of the argument as well, Tom. If you're dealing with a one-man company, sole shareholder, sole director, same person, does the Duomatic Principle in those sort of cases apply to give the director carte blanche, essentially?
I don't think the Duomatic Principle really does come in that context, because I mean, Duomatic is really about saying the company can't complain about whatever it is the company's now complaining about, whether the company's complaining as claimant or whether the company's interests are being represented by an office holder in an insolvency situation. The company can't complain, it said, because all of its members agreed to this. To this thing, which if they'd agreed to it by resolution would undoubtedly have been lawful vis-a-vis the company. But where you have a single person company, then I mean, by definition, the single person has got fully informed consent to everything that goes on, because it's that single person that has decided to go ahead with the transaction. The territory that you're more likely to be in there, I think, in the insolvency context is, well, was whatever that individual did a breach of duty to the company? I mean, there's a case called HLC, which I remember from being involved in quite a few years ago, where this sort of thing arose, and it was one of these questions about intruding into creditors' interests, intruding, and it was a company that was, on the face of it, apparently entirely solvent, and therefore the decision of the effectively sole shareholder, sole director, to cause a large loan to be repaid by the company to the director was really nobody's business but his. But it was able to be established on the facts that for various reasons that the company's insolvency, although it was over the horizon, it was definitely coming over the horizon, and was going to come over the horizon and hit the company pretty much come what may. And so creditors' interests intruded, and therefore that was a breach of duty. A breach of duty technically to the company, but in practice to the creditors, because their interests were such that they had to be considered. But I don't think in those circumstances Duomatic has much of a role to play, because by definition the company has assented. The question really is whether the company's assent is good enough in those situations.
Thank you, Tom. Daniel, I think we are at the end of our questions. So unless anybody wants to send through a quick question now, I will say thank you for watching. We hope it's been informative. Please do feel free to contact Daniel or Tom or any of us as a follow-up if you've got a question or a query. And thank you again for your attention. Thanks, Daniel, Tom.
Thank you very much, everybody. Thank you.
Thank you very much, everyone.